Of course, the retention of records rule we've talked about many, many times. 3 years from the date of last activity. Got to keep all records as a real estate broker for 3 years from the date of last activity. We also talked about the compensation rules, if you will. And I told you the easiest way to just group them all together. In a nutshell, as a real estate broker, you can receive bonuses, commissions, rebates, incentives, etc., so long as you disclose them to your client in writing prior to making or accepting an offer, if there's one applicable. And so long as they do not violate RESPA. What is RESPA?
Real Estate Settlement Procedures Act.
There you go. Real Estate Settlement Procedures Act. And so remember, RESPA prohibited kickbacks from other settlement service providers. So we cannot give or receive kickbacks from attorneys, lenders, title officers, or title insurance companies, anything like that. As long as it's not a violation of RESPA, and as long as we have consent in writing from our clients, we are okay. That is the most generic way I can teach it to you without confusing you. And so all of these go hand in hand with this. Have to disclose it in writing. And then remember too, this is where Synthil got thrown off a little bit yesterday. This is where the $25 to $50 comes in as nominal, right? We do not have to disclose that to our clients. Anything defined as a $25 bottle of wine up to a $50 gift card, nominal value, doesn't require disclosure. But there are no exceptions for even $1 on the do I need a license. Okay, no exceptions there. How about this question? You read it. Tell me what you think. The key word here is, of course, directly, folks. North Carolina provisional broker may be paid a bonus directly from a new homes builder once they have the written permission to receive this bonus from their buyer client. No, they cannot receive it directly. It has to go through whom? Their bank. Their bank. Provisional brokers can only be paid by their broker in charge. Synthil, arguably, even nominal things, while they would not necessarily need to be disclosed to your clients, technically the way the law is written, even the $50 gift card would have to go through your BIC, because if you're a provisional broker, because there is no exception to any number there. It's any compensation going to the provisional broker has to go through their broker in charge. Somebody have a question? Let me ask you this before I switch it over, folks, just as a reminder in North Carolina, and this does go back with the license laws and commission rules. Back in the contract section, when we talked about the sales contract rule, what two things were prohibited from being in sales contracts per our sales contract rule? No discussion of brokerage compensation is one. And? No disclaimer of liability. No disclaimer of liability. No brokerage compensation discussion. Folks, where do we talk about how much money we're going to make as brokers?
Agency contract.
Agency contracts. There you go. The question was, what two things can never be in a pre-printed sales contract that we use as brokers? And that would be a discussion of our brokerage compensations, including any forfeiture of monies to us, and any disclaimer of liability. Both are prohibited under Rule 58A.0112.
Is there a place where the disclaimer is allowed?
No.
Okay.
I mean, we've got duties under laws and rule. I mean, there is disclaimers under like dual agency that says, hey, if you don't like the outcomes, but we didn't do it wrong, that's on you. But there is no full disclaimers of liability in general as a broker. We better know how to do our job.
The WREA.
What about that?
It explains it in that.
It explains how agency works, but it doesn't explain that we're absolved. If we screw up, we can be in trouble. Yeah. So it's just reiterating, right? Folks, you can use any sales contract. It doesn't have to be the 2T. Remember, we taught you a lot in that section. The 2T just happens to be a very commonly utilized one, and the 2T is most commonly utilized, well, it's appropriate for what type of transactions? Sales, more specific. Residential, more specific. Resale residential. There you go. Resale residential by default is suitable for resale residential. But new construction would either need an addendum or a separate contract called the new construction, after purchasing contract, new construction. We talked about the closing statement as well. We said that we have to review it for accuracy, not of all items, but anything we should reasonably know. Once again, be very cautious of that word all. And if we say that a broker is responsible for all items on the closing disclosure, that's not a true statement. Only the items that we should know. And then, of course, the Timeshare Act. We talked about that very early on. So the quick reminder, North Carolina Timeshare Act defines how timeshares are looked at and handled in North Carolina. And of course, talks about there is the project broker, because you do have to have a license to sell timeshare, real estate license to sell timeshares in North Carolina. You do not have to have a license to be the developer. And so, of course, the developer is the one that can get in trouble with the North Carolina Real Estate Commission for violations of the Timeshare Act. The licensee would just be subject to disciplinary action as a real estate broker. And so there is something called the registrar, which is the person who registers the timeshare once it's purchased with the North Carolina Real Estate Commission. Because you do have to register the project, you have to sign the project broker. All of that has to happen, and they have to be approved by the Real Estate Commission. The most testable aspect of the timeshares, though, we told you, was the 5-5-5-500 rule. In North Carolina, the definition of a timeshare is 5 or more periods over at least 5 years. 5-day rescission period on the purchase of all timeshares. $500 fines for the any violation of the North Carolina Timeshare Act for timeshare developers with no maximum. And if you think about the definition of a timeshare, 5 or more periods over 5 years, those combine as how long monies have to be held in escrow. Okay, 10 days. 10 days.
They said, why is it so hard to get out of a timeshare? Like, why is it never ending?
Because you own it, right? You own that fractional piece of time. And so in order to absolve yourself of it, you have to sell it to somebody else. And you got to think about the high pressure sales tactics that exist to try to talk somebody into buying it. Good luck trying to force somebody into buying it from you, because you don't have all the money to do into it. Most people don't want them. And unless you really, talk it up, you're not going to get out of it. So, it's a really just a conundrum, isn't it? Yeah. For $1 on eBay, people sell their timeshares that cheap. Probably. Yeah. There you go. There's something else I want to, oh, here we go. Let me focus on this, folks. Just a word of caution. I'm about to give you a question to reinforce this. The developer must provide the public offering statement prior to contract formation, okay? The public offering statement is all the details. How many units it's broken into, what are the service fees, how long does it go for, or if it's in perpetuity. The public offering statement is all the details, kind of similar with the condominiums as well. And so the legal requirement is for the potential purchaser to be provided with the public offering statement prior to contract formation, not prior to showing the property. You can show the timeshare, discuss the timeshare. You can do all that stuff without them receiving the public offering statement. But they have to get it before they form a contract. And as we said, $500 fines with no maximum for any violation of the North Carolina Timeshare Act. So here's a question to show you what you got to be cautious of. Broker fails to share the public offering statement with a potential timeshare purchaser prior to showing 3 separate timeshare units. The North Carolina Real Estate Commission may fine the developer $1,500 for this action. True or false? This is false. Keyword is showing. They failed to share the public offering statement prior to showing. It's not required before showing. It's required before contract. Now, if they had entered into 3 contracts without it, they would have gotten fines for all 3. But prior to showing is not a violation of the Timeshare Act. Just a few more questions and we're done with all the slides and we'll go wherever y'all want to go. Folks, here is the first one. The North Carolina Real Estate Commission may, after a hearing, take disciplinary action against a licensee who has which of these? Both. We just talked about this. Criminal convictions, disciplinary actions by their licensing boards, and military court martials all have to be reported to the North Carolina Real Estate Commission within what time frame? 60 days. 60 days. 60 days. And so if you report your disciplinary action with the South Carolina board within 60 days, the Real Estate Commission of North Carolina may take action upon you if they consider you to be unfit to be a licensee in North Carolina based on that. Oh, tricky, tricky. How about this one? Real estate license must be renewed no later than every... There you go. June 30th. Okay, you can pay as early as May 15th, but you have to pay that $45 by June 30th. Currency keeps you current. Failure to pay expenses make you expired, and expired is a standalone status. How about this one? In North Carolina, real estate brokers must folks, very important that you realize words matter. Words matter. Some of you are picking C, hate to break it to you, complete continuing education each year in order to keep their license may be active, but not current. Renewal fees deal with current. C is not a true statement. However, if they did not include the name of their firm, they would be guilty of a blind ad and ergo in violation of license laws and commission rules. We just talked about blind ads. Got to the name of the firm in all advertisements or sole proprietorship, but obviously don't put things in the question that are not there. How about this one? So we're going to beat yourselves up on this one. Remember, words matter. This is a provisional broker. How many days does a provisional broker have to deposit earnest money. The provisional broker is not depositing nothing. But they've got to take it to their BIC immediately. Immediately. Don't try to answer fast, just try to answer right. You know what I'm saying? It's not a race. Okay, it's not a race. How about this one? This is true. We said that the bank had to agree to turn over records upon request to the North Carolina Real Estate Commission. Also had to contain the name, trust, or escrow account in the ledger, statements, deposit slips, checks, all that jazz. Has to be a federally backed depository. Could not be a credit union. Had to be lawfully doing business in North Carolina. All the above. What you got, Brooks?
Question never said if it was a North Carolina real estate broker. So could that be construed as a false? Because you did say words matter.
No. Don't put things in the question that are not there. Answer to the best of your ability. Plus, we're never going to talk about like a Nevada real estate broker and a North Carolina exam, right? It's just not going to happen. I'm with you. How about this one? You read it for a second. Tell me what you think. Let me clarify the question, and I think that'll help because y'all are all over the place on this one. Okay, like hold on, this is Joanne, broker of Go Realty, is showing her house to her client. They look at 10 houses before he asks to see one that is listed with Go Realty. On his buyer agency agreement, he declined dual agency. So we're talking about a written buyer agency agreement. He declined dual agency. Can Joanne show him a home listed by their firm if he declined dual agency? No. Why are y'all saying yes? No. It's this you can switch easily from oral buyer agency to seller sub agency, but we have a written buyer agency agreement. And so the question is, in this agreement where we're representing them as a buyer client, can we take them still as a buyer client to see this house when they said no dual agency?
What do you do in that situation then?
You get them to change their mind. That's it. Folks, if they had originally sign and say no dual agency, we cannot take them to go see that property. But if we come back to them and say, if you like this property and you want to see it, you're going to have to consent to dual agency, and they amend their agency agreement, we're good. But you've got to understand, like, your written buyer agency agreement is never going to automatically terminate. We're that's not going to be the case. Don't confuse oral with written. The question is quite literally, if they don't consent to it, can you do it? The answer is no. And so remember what we said when we looked at the buyer agency agreement and the listing agreement, where we said, they want exclusive representation only. I explained to you, if I have a buyer client and they say they want exclusive representation only, I cannot take them to see a listing that is listed by our firm. And if I have a seller who says I want exclusive representation only, I cannot allow a buyer that's list with our firm to see that property, right? They have eliminated a big pool of buyers as a seller, and a buyer has eliminated a big pool of sellers or listings. Does that make sense here? But they can always amend it. They can change it. But it's not like an automatic thing. So don't ever just say like, oh yeah, it automatically switches to something else. It doesn't. We've got this written agency agreement and it's pretty set in stone unless we all mutually agree to end it. Now, going back to that point, folks, if they said, no, I will not amend it, but I want this house, could we then mutually agree to terminate that relationship, refer them to another agent, collect a referral fee? Sure, we could. But it's not an automatic thing. This is not oral. This is not an easy peasy to kill thing. Lisette says, I mean, they can see the house, but if they like it, they can, I mean, technically, no. They're not even allowed to see it. Now, in the real world, will they probably take them to see it and break the rules? Yes. But legally speaking, you're not even supposed to take them to see it unless they have consented to dual agency. And that's how you need to answer on the test. Everybody with me?
Would this be something like you tell them in the beginning, though? Like, I will not take you to any houses.
Yeah, remember when we looked at the buyer agency agreement? I told you, if they said, I want exclusive representation only, which is what happened here, Bree, you signed that. I say, understand that if you're telling me you don't want dual at all, I cannot take you to see any listings listed by my firm unless you change your mind down the road. So then when you like this house, I'm going to say, Bree, remember what we talked about? I can't take you to see this house as your buyer agent because you did not consent to dual agency. But if you'd like to switch it, let's consent to dual agency. Of that, let's do designated, and we'll make sure everybody's good with it. And I'll be the designated buyer's agent, and then we'll be easy peasy, right?
Okay. So also in that, oh, you said you'll be the designator. Okay.
Well, and I clarified that just because that's going to be better for you, but it's not automatic.
Yeah.
Yeah.
So I was saying, if I did that, if they said, okay, let's change, then I take them to the house, but I can't help them with anything.
Say that one more time.
Because basically, unless I get my BIC to approve it
If we're designated, yeah, you can take them. If they approve dual,
I can't say anything or help them.
there you go. You're not going to be an advocate. If we're just doing dual, they consent to dual, but it's not designated. You can take them to see the house now, but you can't advocate for them. So when they say, I want to put in an offer, you say, what do you want to put in? Slick. Yeah. How about this one? Yeah. True or false, the offer to purchase and contract addresses the seller's remedy for breach of contract by the buyer? Absolutely does. In the instance of a buyer breach of contract, the seller's sole and exclusive remedy is retention of the due diligence and or the earnest money. In the seller breaches contract, what are the buyer's remedies, folks? It's not court automatically. Specific performance is one appropriate. Consider the contract in full effect and seek the remedy of specific performance, which is suing them to force them to sell the house. Bill says get earnest money back. Brad, let's add those together. Get all deposits back. Plus, what else? It's actually a little more than that.
Money for inspection.
There you go. All the due diligence money. All the due diligence money. So those are if the seller breaches, the buyer would be able to get back, they would either elect to terminate and get back their due diligence money, their earnest money, and all costs associated with their due diligence period, or elect to treat the contract in full effect and seek the suit for specific performance, forcing the judge to make them sell their house. Those are the two options. How about this one? There you go. True or false, Joanne Broker is a provisional broker with Go Realty. Therefore, she cannot work as a designated dual agent with David Bennett, also a provisional broker of Go Realty. That is false. Every combination is A-OK except for a provisional broker against their broker in charge. Okay, their broker in charge. So, As long as we're all on the same page there. PB can go against a PB, full broker can go against a full broker can go against a provisional broker, full broker can even go against their own BIC. The only one that's off limits is a provisional broker against their specifically broker in charge. Let's add in 3. I don't know why this says 2. I don't know if I messed that up at some point. The 3, let's go with the 3 requirements in North Carolina for an area to be considered heated square footage. Finished. Permanent heat source. Yeah, we'll take the attached, better expanded as accessible from other heated areas. Attached isn't always necessarily enough. So there you go. Permanent heat source, finished, and directly accessible from other heated living area. Now, some of you were saying 7 feet. That's part of the finished, right? Like finishes to the rest of the house, drywall, paneling, hardwoods, linoleum, tile. Minimum height of 7 feet. Except where there's ductwork that has to be at least 6 feet 4 inches. And then, of course, in rooms with sloped ceilings, as long as at least half the room is 7 feet, you can count the whole space up to the area where these slopes are at least 5 feet from floor to ceiling. How about this one? There you go. True or false, as the seller's agent, you are required to verify the accuracy of the title charges on the settlement statement. A lot of you are telling me false. Not entirely. I mean, obviously, you know, we don't necessarily know the title charges. The big issue is that is a buyer's expense. And so you would want to make sure that, you know, the buyer stuff was correct as a buyer's agent, not the seller's agent. Title stuff is a buyer's expense. I'm not saying we would necessarily know all the title expenses, but, you know, only what we know. Blah, 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 blah. How about this one? There you go, Brad. Liquidated damages. What would be an example of liquidated damages? Earnest money. There you go. Folks, we talked about this in the basic contract law section when we talked about monetary remedies or monetary damages. Liquidated damages, a pre-negotiated amount between the parties that says, if I breach contract, here's what you get. Liquidated damages, what it's called. Earnest money is an example of that. Due diligence is not liquidated damages because due diligence is a fee to purchase and have the right to terminate for any reason or no reason and investigate the property. You're not in breach when you terminate during due diligence. You paid to have that right. So earnest money is an example of liquidated damages. How about this one? There you go. Debt service. Money's too vague. Debt service. When calculating a property management operating budget, what is never included? Debt service. We stop at the NOI. Remember, NOI, the net operating income, is a universal metric. It'll be the same for whoever owns it. Debt service would be different depending on how much you put down. And so that's why it's part of the cash flow report, debt service is, but it is not part of the operating budget. How about this one? Here you go. True or false, all agency agreements must include the broker's license number and anti-discrimination clause. That is true. What are the other two things that have to be present in all North Carolina licensing or agency contracts? Not the firm. Definite termination date. There you go. And not a legal description. And then we already got the license number on here. Signatures of the parties. Signatures of the parties. So, non-discrimination provision, the individual broker's license number, definite expiration date, and signatures of all the parties. Those are the 4 required in all agency agreements in North Carolina. How about this? There you go. False. True or false, brokers are required to retain the working with the real estate agent's disclosure for 2 years. It is 3. 3 years from the date of last activity. How about this one? There you go. Which scenario best demonstrates first substantial contact? Folks, you got to have some powerful stuff to be able to use it in a negotiation or use it against somebody. 3 says must. That is the only one strong enough to dictate that you might be able to use that information against them. That is the only one that's first substantial contact. The rest of them are too vague, too loosey-goosey. How about this one? Folks, word of caution here. Once again, don't ever put anything in the question that's not in here. True or false, a dual agent may disclose confidential information about their seller client to other brokers working for the firm. If they disclose it, what can anybody else in the firm do with it? Nothing. Nothing. So why does it matter? Dual agency, bound and gagged and worthless. You could have a sales meeting in a dual agency transaction and you tell the entire firm, arguably speaking, so you understand this concept, all the details of the buyer and the seller, and it's not going to matter. Why? Because nobody can use it in dual agency. But why would you probably not want to share information around the office about your clients?
So you can do designated?
There you go. So you can do designated. Now, arguably, the answer on this, and I'm looking at it, and I don't know how, I think this one got jumbled up, which is why I'm not really like focusing on what the written answer is. The fact of the matter is, you could share information if you're already in dual agency because you're already in worthless mode. But if you're not in that territory of worthless, you would not want to do it because you would potentially preclude you from being a designated agent down the road. So I don't really want you to focus on what's written here because it's kind of worded in a silly way. Black lung. How about this one? And Beverly says in case the status changes. That's exactly right. True. If the deal falls through. Yeah, this is kind of a big one, and I don't know that I necessarily spent enough time explaining this one, but you still all got it right, which is great. True or false, a broker property manager in North Carolina can deposit rent checks directly into the bank owner or the bank account of the property owner. The way that the trust account rules are written is if any monies come into our possession belonging to others, we are not supposed to act as a courier for them. We need to deposit them in our trust account, allow them to clear, and then we could disperse them into our property owner's operating account or whatever it may be. The only exceptions to that way that rule is written is due diligence and earnest money checks. We are allowed to act as a courier for those, even though they're made out to other people. Those are the only two exceptions. If monies belonging to others comes in our possession, it's supposed to go in our trust accounts, clear, and then be dispersed to them. That's the way the rule's written. What you got, Brooks?
So, for the purposes of the exam, we need to treat rent checks just like we would a provisional broker would treat earnest money deposits.
No, this is not an immediately thing. No.
Right, but I'm saying like they can't deposit it directly into the owner's account. Like it has to go through the escrow account.
It does, but like I said, I still wouldn't necessarily group it in with like the provisional broker aspect, because what I'm saying here, I mean, what this equates to, if you own a property and I'm your property manager and I'm a broker in charge and I have a trust account and the tenants are paying me the $2,000 a month rent check, but obviously that's going to you after management fees and things of that nature, you know, even though part of it's going to go to you, I wouldn't put it directly in your account. I would put it in my trust account, allow it to clear, and then I would disperse out my portion, your portion from that check. You know, it has to, that's what this looks like. Whereas earnest money checks, when we get them made out to like the escrow agent, or due diligence checks made out to the seller, we can just cart those over to the person that they belong to.
That was confusing.
What do you mean?
So I would have thought it was false because it would have gone into an operating account, and this looks like it's going into like to me it reads like it's going into the personal account of the property owner instead of like
well, it doesn't really matter where I mean, I'm sure it is going to be an operating account for the owner, but the point is, if the monies come to us, right, if they're sending them to us as a property manager directly, so I mean, the thing is, we can't just deposit it in your account, and we can't even just take it to you directly. If it comes to us, the way the rule is written, you have to deposit it in your trust account, allow it to clear, and then disperse it to whatever account the owner wants it to be dispersed to. Don't get so caught up on whether it's an operating account or their personal account. The point is, we can't deposit it directly there if it comes to us first.
Okay.
Yeah.
Yesterday you mentioned that they don't have to have a trust account.
Who doesn't have to have a trust account?
The broker.
What are you talking about? I said that a firm, don't hold on now, don't go to squirrely on me. I said a firm is not by law required to have a trust account unless they're handling trust monies. And we said multiple times it would be almost impossible for a property management brokerage firm to not have a trust account, because rent checks and tenant security deposits are both trust monies. Yeah. Bree says, what was the timeline on cash rent deposits versus other methods? Trust monies that are cash have to be deposited within 3 days from receipt, regardless of whether there is a contract or not. Checks can be held once they've been delivered up until the time that the contract has been accepted, and would have to be deposited within 3 days of contract acceptance. How about this one? Here you go. That's true. Verifying the accuracy of all things that we would be aware of, right? At closing, North Carolina's buyer's agent in a residential transaction is expected to verify the settlement entries reflect the terms of the sales contracts and all amendments. If we amend the contract for a new sales price, if we change the closing date, if we change the credits, we need to verify that all of that is accurate. Yep. Folks, last couple questions, and then we're going to talk about anything and everything y'all want to talk about. Okay, here is the next one. Answer that one for me. There you go. True or false, a dual agent representing a seller is not permitted to share material facts about the condition of the property with the buyer. False. Material facts are owed to everybody in the club getting tipsy, right? Buyers, sellers, doesn't matter. Clients, customers, everybody gets it. How about this one? Donnie, you have a question about this one, or you got a question about something else?
I have a question about a question that was on one of the practice questions that was very similar to this.
Mm-hmm.
And I got it wrong. I coded it as puffing, but it's actually, well, some folks are answering it now. It's actually misrepresentation. And I'm not clear on the nuances of the difference there.
Yeah, let's talk about it. Puffing has to be subjectively true to somebody. Folks, would this be subjectively true to somebody if the only time that you could see the river was on the roof? When was the last time you stood on your roof to get a view of anything? This is a willful misrepresentation. Liar, liar, pants on fire. If you could see the river, but it was like a weird angle of it, that'd be puffing. Because subjectively, it may be true to somebody. You can't see the river from the house. This is a misrepresentation. Does that make sense?
Yes, that's clear.
Yeah. If I say best view of the golf course and it's looking at the clubhouse, it's still the golf course, subjectively true to somebody. If I say best view of the ocean and the ocean is there, I'm not in trouble. It's if it's not there, I'm in trouble. And you're not going to see the view of the river from the house. It's only visible from the roof. That is above and beyond puffing. Puffing is not a violation. Got to toe the line, but this one is a violation. How about this one? There you go. If a buyer or seller client wishes to add unique provisions to the contract that would not be covered by the standard addenda, the broker should advise the client to contact your attorney. And forevermore, some of you are going to hear CYA, and you're going to think contact your attorney, even though that's not what you've learned it as initially. I think I got 3 more. This one?
Oh, what is the CYA?
CYA, contact your attorney.
Oh, okay.
True or false? Broker is required to disclose that a property is within a federally recognized flood hazard zone as a material fact to all prospective buyers. You all said true. I'm inclined to agree with you that that is absolute material fact. Have to be disclosed. True. How about this one? This would be false. Remember, you can use any pre-printed sales contract so long as it contains the 19 required provisions and does not contain the 2 prohibited provisions. It's just that the most commonly utilized ones are the standardized forms put out by NC Realtors. But those are not the only ones. You could have it. Builders don't use our standard forms. Builders have their own contracts drafted by an attorney. And that's fine as long as they meet those requirements. How about this one? Yep. Just talked about this. This is true. This one. Yeah, there you go. True or false, a licensed appraiser must have an active broker's license to manage real property for another person. True. Being an appraiser does not give them the authority to do that in any way, shape, or form. How about this one?
It's not for compensation.
Don't put things that are not in the question, right? I mean, managing property for others, obviously this is not structured like a test question. It didn't say that there was or wasn't. Go with there was. There you go. True or false, a licensed real estate broker may draft a loan contingency addendum for their buyer client negative ghost rider. Our clients could draft them themselves, not advisable. Best to contact an attorney. Last one I got for you right here. There you go. Material facts relating directly to the property, such as scheduled road expansion, etc., must be disclosed to all prospective buyers. Arguably all people all the time, but really only people who need to know. We're not going to tell random people about house issues because they don't need to know that information. Folks, let's go wherever you want to go.